Welcome to the top 12 highlights for Chapter 15. We're looking at civil liberties. Let's differentiate between civil liberties and civil rights for a moment. We talked about this in class, but the idea here of civil rights is we have equal protections for people based on certain characteristics to make sure that they are protected under the law, as everyone is. This can be based on race, on gender, on disability, to make sure that everyone is protected equally. Civil liberties are protections against the government in terms of a particular right that everyone has to make sure that they continue to have that, and it's across the board. It's not based on a current characteristic, but it's based on everyone has that right, such as freedom of religion or freedom of speech. So that's the main difference, and we'll go into much more depth on civil rights in the next chapter. Selective incorporation is this idea of applying the Bill of Rights to the states on an amendment-by-amendment, case-by-case basis. This is probably the most important concept in this chapter on civil liberties, because it is about taking the Bill of Rights that in 1833 was in Barron v. Baltimore was a case in which the Bill of Rights did not apply to the states. They did not have to abide by the Fifth Amendment and eminent domain, and basically looked at from that time for almost 100 years until Gideon v. New York in 1925, basically said the Bill of Rights don't apply to states. And it wasn't until the Gitlow case, the free speech case in 1925, that the Supreme Court said the states do have to abide by the Bill of Rights, and they started to selectively incorporate on a case-by-case, amendment-by-amendment journey, in doing so to selectively incorporate the Bill of Rights, and that's what we see today. So a number of cases we'll look at here, but the idea is that is selective incorporation, the idea of applying the Bill of Rights to the states on a case-by-case, amendment-by-amendment basis. The last rights to be incorporated were from the Second Amendment. This is the D.C. v. Heller case and McDonald v. Chicago, and they were basically on the right to own a handgun, and basically the restrictions that were placed on them by the D.C. government and the Chicago government were found to be unconstitutional, violation of the Second Amendment, and that was the last right, the last amendment that we have seen selectively incorporated up until now. In the First Amendment, we go back to the Establishment Clause and the Free Exercise Clause. Let's kind of differentiate there for a second. Establishment Clause, looking at it in terms of the government is sponsoring or showing favoritism to a particular religion, and thus establishing a government-sponsored or government-sanctioned religion. And that liberal justices kind of see that more as a strict separation, where conservatives kind of look at that in terms of, well, you can't establish a theocracy, but otherwise there's a lot of wiggle room. So that's kind of ideologically how that breaks down. But in Engel v. Vitale, we see students leading a non-denominational prayer in school is a violation of the Establishment Clause, according to the Supreme Court. They ruled that unconstitutional. It was a violation of that Establishment Clause. Now, the Free Exercise Clause is about your ability to exercise your religion. Now, keep in mind what we talked about. Your rights end where another person's rights begin, and this is never more present than in a free exercise type of situation. So we talked about the case of employment Division of Oregon v. Smith, in which they wanted to smoke peyote as part of their religious exercises on breaks while they're working for the government. No can do. Government didn't like it, said that you can't do that, and the Supreme Court agreed in saying that the government can compel you to curb your free exercise, especially and an employer as well, when it comes to your work on the job. You agree to certain standards, and one of those is part of your conduct. So they cannot government cannot force you to take part in a religion, but they and obviously in Article 6 of the Constitution there's no religious test, for office, for running for office, but they can limit or place restrictions on the conduct, especially when it comes to your religion is violating another law that is in place. And Dr. Magleby in the text talks about the idea of drug use, as I mentioned, and polygamy as another. Some school cases that we took a look at. Tinker v. Des Moines, the idea of symbolic speech is free speech, is the case in which Mary Beth Tinker, who visited our school last year, and we had the great pleasure of having her there to talk about her experiences, and her brother were basically suspended for wearing armbands protesting the Vietnam War to school. It wasn't a disruption of the educational experience, and the court said as long as it wasn't a substantial disruption, which it clearly wasn't, she was allowed to do that. It was a part of her free speech rights under the First Amendment. Now, Hazelwood v. Kuhlmeyer, you'll remember I go into more detail on these cases in the chapter notes, so if you want to go back to those, the full version of the Mr. Rodman's Chapter 15 notes, you're welcome to do that on YouTube. You can find that clip as well. But here, this was the idea of prior review. Hazelwood v. Kuhlmeyer was the issue of administrators have the right to censor school newspapers. Now, we in Montgomery County don't have prior review. Administrators aren't looking at that material before it's published. But many schools do across the country, and it's the Hazelwood case where administrators get that right. Lee v. Weissman, can we have a member of the clergy give a prayer at graduation, an invocation? In 1992, the Supreme Court said no. It is a violation of that Establishment Clause issue of the government holding a graduation and calling on, well, which member of the clergy are you asking? Which denomination? Which religion? What kind of prayer are they saying? There's a lot of unknowns, and too many unknowns for the Supreme Court, so they ruled it unconstitutional. And in the West Side Community Mergens case, basically, if you allow students to form clubs, you must allow religious students that want to form clubs to form them as well. So they can have religious clubs in addition to clubs at your school. And that's pretty consistent across the board. The court has struck down school prayer, creationism, again, the ministers at graduation, as we talked about there, and organized prayer at high school football games. Obviously, students can exercise their rights to pray at any time throughout the school day. Many do it before a quiz or a test, maybe at lunch or before school or even after school. Whew, glad that test is over. But the idea is that you're doing that individually as a student, and you're not disrupting the educational experience of other students in so doing, and therefore the Supreme Court has upheld those types of free exercise issues. In the case of West Virginia v. Barnett, do students have to stand for the Pledge of Allegiance? The Supreme Court ruled in 1943 that they do not. They do not have to stand as part of their religion, saying that it didn't require them to stand, and the religion asked that they not take a pledge of allegiance to a flag. And in this case, the Supreme Court upheld that ruling. They also said that teachers or administrators can't force you to say the Pledge of Allegiance, and that is why we're allowed to say please stand, and that's kind of where we leave it. But we cannot compel that in terms of if you want to say it, you can. If you don't, you don't, and we move on from there. The Fifth Amendment, eminent domain. There's a lot in the Fifth Amendment that we don't talk about. The main one we always hear about is the Fifth Amendment. You have the right to remain silent. Anything you say can and will be held against you in a court of law if you don't. That sort of thing. But there's also eminent domain in there. There's also double jeopardy in there. And let's talk about eminent domain for a second. So this is the right of government to take your private property and give you fair market value for it if they're going to use it for a public function, such as a highway or a road or a convention center or something like that. They have to give you fair market value, the idea of just compensation, but they are allowed to take it. And in the case of Kello v. New London, this is up in Connecticut, Kello basically didn't want to sell, didn't want to give up the property, and the Supreme Court ruled in 2005 that they had to. If it was a public use, and this was one of those public-private partnership type of deals, it was a city center kind of thing that was also going to be private development in addition to public spaces, and the Supreme Court ruled that it was it was within the eminent domain parameters of the Fifth Amendment for the government to take the property. Now, long story short, Kello got such recognition from the case and so much money and donations coming in, they were able to move the home to another property. And long story short, after this, the financial crisis hit and the project ended up imploding. So to this day, it is a grassy knoll. The city never did anything with that property, so it still sits, and Kello's former property still sits empty. Freedom of speech, we look at the idea that there are many cases that we can look at here in terms of we have to define the different types of speech that are available, ones that are protected, ones that are restricted, and ones that are not allowable under the First Amendment and freedom of speech. So let's look at libel first. This is about defaming in writing another individual. For an elected official, this is really hard to prove. For an average citizen, it's a little easier to prove, but again, you still have to you still have to prove actual malice. You have to prove that the statements were false and they knew that when they printed them. And that's basically the finding of the New York Times v. Sullivan case. If it can be proven that they knew they were false, they printed them anyway. Again, very high standard, but if you can meet it, you can win a libel case. Carol Burnett, back in the 80s, basically sued a tabloid for printing something about her that they knew clearly was false, and she won, but she went through many court battles and, tens of thousands, if not hundreds of thousands of dollars to win. So it really was hardly justice, but she was able to. It was more the point of the matter that she was trying to prove there. Obscenity is more a community standard, kind of the I know it when I see it. And Miller v. California, the 1973 case, is where we established this. We basically have this idea of slaps. Is it serious literary or artistic, political, or scientific work that we're talking about? In which this is, if that is the case, it passes the slaps test. It's not obscene, and it may be covered under the First Amendment. But if it isn't, and it doesn't meet those standards of serious literary or artistic or political or scientific value, then what does the community standard in which this thing is potentially obscene? And the community standards have really been upheld since then in the Miller case, and since then we've seen the same type of thing. So your speech, what some may view as art, other may view as obscene, and again, the community standard is applied there to determine if slaps allows it to stay or if it is obscene and must be removed. Fighting words, we know hate speech is different from hate crimes, but you got to be very careful here. The idea of hate speech is protected speech as long as it doesn't incite violence or encourage or in some way propel others to commit illegal acts. If that is the case, they're encouraging people to riot, they're encouraging people to hurt other people. That kind of hate speech crosses a line, and at that point, it is no longer speech, but essentially permissive action that you're trying to get people to take, and that is not a protected speech under the First Amendment. And that's where we get into hate crime. If someone is committing an act for the purpose of targeting a particular characteristic of people, such as race or gender or disability, that can be classified as a hate crime. And we do have a hate crime standard passed by the Matthew Shepard Act in Congress several years ago. But the idea there is that states also have additional punishments for hate crimes in terms of sentencing guidelines. So hate speech as words alone are protected speech under the First Amendment, but as it incites violence or is a call to action for people to commit illegal activity, that would not be protected speech. Advertising is another area that's also a pretty gray area. We see lots of commercials a lot of times with misleading or false information. The Federal Trade Commission steps in on a lot of those, but again, the idea is that much of it tends to be free speech, but again, if it is a product that you're pushing that is illegal or false information or leading people in the wrong direction. A lot of times the Federal Trade Commission will come in and nip that in the bud in terms of taking that off the air or issuing a recall and fining or removing the license for that particular company or division. Another school case, the Bong Hits for Jesus. This was Morse v. Frederick. You cannot put up free speech doesn't extend to signage and speech that includes endorsing illegal activities. I talked about with the hate speech. When it gets to that level, it, just like the hate speech, is no longer free speech. It's no longer protected under the First Amendment. Let's talk for a second about due process. Procedural, the idea you're following the method of the law, you're following the process that's in place. Substantive is about fairness. Is it really fair in terms of, like in this Regalt case that you see here, is it fair that juveniles were treated to a different standard than adults? And the court said, no, it's not. If you are being accused of a crime and you're a delinquent, you're a juvenile and you're being accused of a crime, you can't be given another set of standards of due process. You're entitled to the same due process rights as adults do, not more restrictive or more difficult rights as a result of that. So really, that is the substance of the law in terms of total fairness. The procedural is, are the 5th, 4th, 6th, 7th, and 8th Amendments being followed in terms of a right to a speedy trial, a right to a jury of your peers, a right to know what you're being accused of, habeas corpus, a right to be free from cruel and unusual punishment, all of those things that really are the procedural aspects of due process. All right, Fourth Amendment, search and seizure is about this case, Mapp v. Ohio, basically saying that, hey, this is where the Fourth Amendment was incorporated under the Selective Incorporation that we talked about earlier. This basically said, hey, if you're going in searching for something and you find something else that's not in the warrant, you can't use it. It doesn't work that way. So warrants are very specific these days in terms of what they're looking for and what they have grounds to look into. And unless a judge gives you a pretty wide berth in terms of being able to address them, you've got to stick to the letter of the law. And that's the Mapp v. Ohio case. They basically ruled the evidence that they found, the illegal evidence that they found as a result, was inadmissible. It was excluded, and that's where the exclusionary rule comes from because of this case. So the evidence found in a warrant needs to be specific to the warrant, or the warrant needs to be more vague in capturing information that's much broader in nature. The good faith exception to that, however, is the idea that police may have had the warrant, they knew what was happening, and it was a technical error or something happened that was necessarily done in good judgment, but the courts have ruled it was a good faith exception. And there have been cases in which this was allowed because the court, you can see the 1984 case, you don't have to know this one, but U.S. v. Leon was basically the case in which the police were trying to do everything by the letter of the law, and unfortunately there wasn't a warrant, but they thought the warrant was valid, and it wasn't. So they acted in good faith, thinking that the warrant was still valid when it was not. And as a result of that, the Supreme Court said, hey, this is a case where we understand the police were trying to do the right thing, and were precluded from it because they didn't have all of the information in their hands at the time. And then we look at the Kylo case. This had to do with the Carpenter case we looked at in our mock Supreme Court, but the Kylo case looked at thermal imaging. Can somebody in a police car go by your house, aim a thermal imaging device at your house, and see if you have extra radiation lights in your basement, therefore you're growing marijuana in the basement or something? And the Supreme Court ruled that you can't. That is a violation of search and seizure as well, a violation of the Fourth Amendment. But drug testing on students when it comes to extracurricular sports, as we saw in the Board of Ed v. Earls case, is permissible. Your rights in school, when you submit to taking the class or submitting to the sport in this case, are they allowed to make you submit a urine sample? And the Supreme Court said they are. That this wasn't a violation of Fourth Amendment. This was a situation, and we want everyone on the team to be of sound mind and judgment, and the idea of the school as a government entity to mandate this was constitutional and not a violation of the Fourth Amendment. Now, obviously, that shows you that what rights you have outside of school versus inside of school are very different. And the New Jersey Vitiello case is another one in which just because it's on your person, just because it may be in your locker, just because it may be on school grounds, but it's your private property, doesn't mean they can't search it if they have reasonable suspicion to believe that there may be something illegal in it. Because when you're on school grounds, everything is discoverable, as they say. And that was the point of the New Jersey Vitiello case. Basically, do you have the right to keep those things from the police? The answer, no. Obviously, in lockers, they are owned by the government, so clearly you don't have any wiggle room there. But the idea of backpacks and other materials, there needs to be two people present. It's not a teacher. It's usually an administrator and a security officer or somebody like that. Here in Maryland, those are the standards. But the idea is that if they have reasonable cause or reasonable suspicion, they can search your personal property, meaning your purse, your bag, and what have you. All right, the right to remain silent in Miranda v. Arizona was the case here. He wasn't read his rights. He didn't know that he could remain silent. He didn't know that everything he was going to say was going to be held against him, and as a result, the police officers now carry Miranda cards as a result of this case, basically incorporating the Fifth Amendment and the right to remain silent by saying if you are not read your rights, then they have to they can't hold what you say against you. They can't do that to you. And I will tell the story as I did on the chapter notes that in the case of Miranda, he was set free. And he ended up dying in a bar fight. He was stabbed to death by another patron of the bar. But the patron, when he was arrested, was read his Miranda rights, oddly enough. The right to counsel is under the Sixth Amendment, and that is where we see it incorporated with Gideon V. Wainwright, the 1963 case in which Clarence Earl Gideon was basically accused of breaking into a vending machine in a bar and stealing all of the money that was in it, the coins. He couldn't afford a lawyer, and so he wasn't given one by the court. He said, "Don't I get one?" And they said no. And as a result, he appealed it all the way to the Supreme Court. They incorporated the Sixth Amendment, the right to counsel, and applied the Sixth Amendment to the states by saying that you do have the right to a lawyer, and it is on the Miranda card, as you saw on there earlier, number 3. You have the right to talk to a lawyer and have him present with you while you're being questioned. So when they read the Miranda rights and they say you have the right to an attorney, if you cannot afford one, one will be appointed to you at the cost of the court. That's coming from Gideon, from the Gideon V. Wainwright. So if you ever see those commercials in which they say, if you have a phone or the internet, you have a lawyer, it comes from this Gideon case. And then the last one is Greg v. Georgia, incorporating the Eighth Amendment on cruel and unusual punishment. This also being something that the states have to abide by. Greg v. Georgia was the case. Is it cruel and unusual punishment to use the death penalty? And the Supreme Court said it is not cruel and unusual to use the death penalty, depending on the type of death penalty that is being used. And they have kind of split hairs since then in terms of that cruel and unusual punishment aspect. But they did uphold in the 1976 case that Georgia had the right to use the death penalty, and obviously other states as well. We do not have that in the state of Maryland. We banned the death penalty in, I believe, 2012 or somewhere around there. That was banned. All right, that's the top 12 highlights from Chapter 15. I look forward to talking to you in Chapter 16. Live the 5. Have a great day.